Hello, everyone. Welcome to Court with Krissy. You know you're in trouble when the judge says you could lose your deferral. Stick around for the show cause to see how this lady pisses it away. I hope you like it. Court with Krissy is now in session.
And Your Honor, Ms. Tomlin is present in the courtroom. We had final conference today. There is going to be a plea in each of her two files. I do have a signed advice of rights form for Your Honor.
Okay. All right, we're here in two different matters involving People versus Sierra Kaylee Tomlin, file 4339 of 24, that's the domestic violence, and 4335 of 24, that's the failure to report accident to fixtures. Mr. Connolly is here on behalf of Ms. Tomlin. Good morning. And Ms. Truesdale for the People. So, is there these are both set for final conference. So is there a final conference offer, Ms. Truesdale?
There is, Your Honor. With respect to the damage to fixtures case, there is no offer plus restitution needs to be made. With respect to the domestic violence case, the offer is plead as charged with a deferral.
So with the fail to report, you said no offer in that case?
No offer, Your Honor.
Okay. Mr. Connolly, what does your client wish to do?
Those are accurate offers, Your Honor. She will be accepting the profiles.
Okay, so before I accept your plea, Ms. Tomlin, I want to make sure you understand all of your rights. Is that your understanding of the plea agreement? You'd be pleading guilty to the fail to report accident to fixtures in file 4335. You'd also be pleading guilty to the domestic violence in file 4339, but with the understanding you'd receive a deferred sentence in that case.
Yes, Your Honor.
Okay. Other than that, has anything else been promised to you to get you to plead guilty? Have you been threatened, forced, or coerced in any way to get you to plead guilty? Do you understand if I accept your plea this morning, you'll be giving up any future claim that your plea was a result of promises, threats, or other inducements that have not been disclosed?
Yes.
The way the deferred sentence works with the domestic violence is you'd be placed on probation for a period of 1 year. And so long as you successfully complete the conditions of probation, no conviction would enter. In other words, there would be no public record of this. And typically you would not receive any additional jail time. On the flip side, what you need to understand is if you violate the conditions of probation, a conviction will enter and you could be sentenced up to 93 days in jail. Do you understand all that?
Yes.
On the fail to report accident, do you understand that if I accept your plea, you'll have a conviction for that offense, and that carries a maximum penalty up to 90 days in jail? Has Mr. Connolly answered all of your questions, including going over your trial rights with you? And I see you signed the advice of rights form. Did you read and understand all of those rights before signing?
Yes.
Do you understand that you're giving up all those rights, including the right to a jury trial by pleading guilty? And is that what you wish to do? And is it of your own free will?
Yes.
All right. In the fail to report accident to fixtures case, the complaint alleges that you were the driver of a 2010 Dodge Caliber that was involved in an accident with a mailbox, and that happened in Custer Township in Antrim County on August 2nd. Is that true?
Yes.
And says that you did not make reasonable attempts to locate and notify the owner of the property. Is that true?
Yes.
And that you did not report the accident immediately to the nearest or most convenient police officer. Is that true? Then to the charge of failed to report an accident to fixtures, how do you plead?
Guilty.
I'll accept your plea, find that voluntary, accurate, and understanding. Then we'll go to the domestic violence. It says here that on April 13th, you assaulted David Hutchinson, someone that you have a child in common with, or you have a dating relationship with or had at the time. Is that true? And how did you assault Mr. Hutchinson?
With another object, I guess you can say. I didn't physically touch him, but I ended up kicking like a bucket or something at him, and I ended up hitting him.
Okay.
Yeah.
And it wasn't just an accident. You weren't just fooling around. You were upset with him, and that's why you kicked the bucket at him.
Yes.
Okay. And did it strike him? It didn't. Okay, but it would.
Yes, it obviously hit him, but it didn't to where it would wounded him or anything like that.
He didn't injure him, but he did, did in fact make contact with him.
Yes.
But a reasonable person wouldn't want to be struck with a bucket, even if it doesn't hurt very much.
Right.
Okay. And that all happened in Kearney Township in Antrim County, correct?
Yes.
Then to the charge of domestic violence, how do you plead?
Guilty.
I'll accept your plea, find this voluntary, accurate, and understanding. We'll set both cases for sentencing at a later date. Ms. Martin.
Yeah, December 18th at 9:50.
That's fine.
Okay, and I do want to get a substance assessment and a pre-sentence investigation report. And now we'll take up the show cause hearings in both cases.
I think just to clarify, Your Honor, Ms. Sutton to provide me with the same documents Your Honor has. So we were here last time. It must have been a few weeks back, last month. And I remember Your Honor had said, Ms. Tomlin, you look like you might be under the influence or something, and you had her tested at the jail.
Yeah.
And then I think I left because the test didn't come back till later in the afternoon, but it came back negative, Your Honor.
Okay, it came back negative, but she peed on the floor, and then she put toilet water in the sample. No, that's what happened, because the creatinine level doesn't make any sense. It was not human urine.
Pee on the floor, I thought it was not.
Well, that's what the jailer says.
No, Sherry watched me pee in the cup.
Okay, well, that's the information I have. And
all I knew is that it came back negative, Your Honor. I didn't know anything else. So.
Okay, well, I had a discussion with Ms. Jacobs this morning. That's where I got that information from. We could bring her in here or bring in, was it Sherry, you said, Ms. Knight?
Corporal Knight, the jail's administrator.
Corporal Knight.
Sergeant. Oh, I'm
Sergeant.
sorry. Yeah, I get that wrong.
That's what I thought. Well, we could bring in Sergeant Knight to testify to that, or not testify to that if that's not what happened. Ms. Truesdale,
Your Honor, I have a little bit of knowledge about this as well. I'm not sure if I'm not sure what was done, but I know the test was performed improperly, and it was intentionally performed improperly in order to avoid doing it, is what I've been informed of. So perhaps maybe the details are too much for Ms. Tomlin, but I'm not sure that she executed the test as directed.
Is Sergeant Knight available, even to zoom in?
I can call.
I'd like to ask her a few questions.
Yes, sir.
Okay, so why don't you have a seat for right now? And
7 from 39.
okay.
Oh, maybe we'll have good luck for your birthday.
I hope so.
Sergeant Knight, if you could come on up to the witness chair. And we'll recall the case of People versus Sierra Tomlin, files 4335 and 4339. If you could raise your right hand, do you swear or affirm that this testimony you're about to give will be the truth, so help you God?
I do.
If you could go ahead and have a seat there, and please state your name and how you're employed.
My name is Sherry Knight, ANIGHT, and I'm employed with the Sheriff's Department as a sergeant.
Okay, and Sergeant Knight, were you present when Ms. Tomlin was ordered by the court to take a random drug screen at the jail?
I was for her first one. I wasn't for the second one that was actually tested.
Okay. Do you have records of, or did you talk with anyone else regarding the second test?
I did. Our jail nurse observed her, and when she tested it, it was clean, a clean urine screen.
Okay. Was there any unusual behaviors or anything that caused you concern about the results of that test?
No.
Okay. So I was told, and I'm told a lot of things, I'm checking it out here anyway, that the creatinine level was below 20, which typically means there's been some monkey business going on with the test.
That I'm not aware of.
You're not aware of it.
The first test that I observed her, when she urinated in the cup, she completely missed the cup. And then I went to a meeting, and that's when my jail nurse took over.
Okay, so it didn't hit the floor. It actually went in the toilet.
Correct.
But there was nothing in the cup.
Correct.
Okay. And was there anything else about that observation of the urine screen that indicated to you that she was playing games rather than making a serious effort to test?
I believe so. I believe she missed it on purpose.
Okay. Anything specific other than the fact that she missed, though?
No.
Okay. Ms. Truesdale, do you have any additional questions for Sergeant Knight?
No, Your Honor, thank you.
Okay, or you, Mr.
No, Your Honor.
Connolly? Okay, appreciate your time then this morning. Thank you. Okay, so what's your position regarding bond, Ms. Truesdale?
Regarding bond?
Yeah.
Oh,
Hang on just a second. So Ms. Jacobs is here, and Ms. Jacobs, we just had Sergeant Knight testify about missing the cup, but she was not familiar with the results of the drug screen. Do you have the actual report of that?
I did, and I just uploaded that in the SM case that we have. It was a 5.5 milligram /DL. I was trained when I was a bond officer by Sharice Shively with Community Corrections that anything below 20 is usually inconsistent with human urine. I was also called yesterday by a detective at the sheriff's office that she had law enforcement contact the other night. She had a baggie with residue, and there were needle caps in the car that she was inside, so they were concerned that she has been under the influence as well. And I do not believe that there are any testing results since you ordered her to do, I believe, 8 times a month.
So we haven't received any test results.
There are none, and I believe that's why Officer Chup, she ordered this show cause hearing today.
Ah, okay. So do you have any questions for Ms. Jacobs, who is not sworn in, but I could swear in?
No, Your Honor, I didn't. I wasn't aware of any of this. So
I understand.
But I am now up to speed on what's occurred, and I would advise my client obviously to remain silent with respect to any paraphernalia that may have been located in her vehicle. And I understand. Okay, in the vehicle she was in. I don't want to get into the facts of that, but it appears she hasn't been testing, Your Honor, and she had just indicated she had not tested due to financial issues. But all of what was just said appears to be some basis for that, Judge, without going into detail.
And she was not, Ms. Jacobs, she was not arrested. She's not a suspect in that case that you referred to where she was present?
I believe it's an ongoing, maybe an investigation. It had something to do with, I believe, TNT. I asked for a report just to provide to the bond officer, but I haven't gotten that yet.
Okay. Ms. Truesdale, is there anything else for the people?
Your Honor, I am not aware. This is new to me. I would simply direct the court's attention to the previous violation, which I think Mr. Connolly hinted to, which indicates that there has been previous discovery of hypodermic needles, and I think that there's sufficient evidence of a bond violation here. So I would leave it to the court's discretion with respect to sentencing. But Here it is. I'm sorry. I'm looking at the bond violation signed by Sergeant Skrebecki on October the 10th, which indicates that she had consented to a search of her son's bedroom. During that search, Sergeant Skrebecki located used hypodermic needles hidden in a Trix cereal box, which she admitted to using for intravenous narcotics use. I think that perhaps there is plenty of evidence here of a bond violation with respect to the creatinine level and to the new charges just raised by Ms. Jacobs. Obviously, what happened a month ago doesn't prove guilt.
Do you know how old the child is?
Yes, Your Honor, the child's very young. I think the child is under the age of 5.
Oh, okay, so it's not like some teenager using drugs or something like that.
No.
Okay. Okay, well,
You don't want to talk about taxes.
yeah.
Well, I was saying that I had prior.
Well, hang on.
Talk about that.
Your attorney doesn't want you to comment right now. So, Mr. Connolly, your clients received the benefit of a plea bargain with a deferred sentence, and obviously that's an attempt to rehabilitate. And what's your position on bond at this point? Why is she not testing, especially? That's my concern.
So I think, okay. I think perhaps, Your Honor, she needs to check herself into a rehabilitative treatment program. I would understand if Your Honor was going to remand her, but if that's an option for her, could the bond perhaps allow for increase in money for treatment purposes? Because it looks like, Judge, while we're not here for a drug case, I think we're fortunate we're not here for one, it sounds like. So before we get there, this might be the time to deal with it.
Okay, Ms. Jacobs, that sounds like a good plan to me. And I'm going to note a 5.5 creatinine level is extremely low. I see them below 20, sometimes 17s and 18s and 16s, but 5.5 is very obvious to me that this was not urine at all. And so there's no doubt in my mind she missed the cup on purpose, probably used toilet water rather than urine for the second sample. There's evidence of drug use on 2 different occasions, and she's not testing at all. So, Ms. Jacobs, I think that's a good idea, inpatient treatment. Usually with our drug court, we can get folks into treatment within about 10 days or less. Do you think that's an option here? Or?
Your Honor, I believe, and I'm not entirely sure, but she has called before when she missed court saying she was going to treatment during the pendency of this case. If you want me to help her get into treatment, I am more than happy to, but I think she needs to be in the jail and sober before, and we can arrange proper transportation to ensure she goes to treatment, in my opinion.
Okay, so I think that, go ahead, Ms. Truesdale.
Your Honor, thank you for hearing me. I would echo Ms. Jacobs' concerns. Also, it has been my experience in the past that when people are able to check themselves out of inpatient treatment, they proceed elsewhere. And I think part of the court order I'd request be that if she is to leave treatment, she has to be remanded to jail.
No objection, Your Honor.
I finished rehab
Hold on.
We're
going to let the judge talk.
Okay, you've been to rehab 3 times?
No, once, sorry.
Oh, once.
Yes.
Okay. Well, it doesn't always stick the first time. Right. I know that. But hopefully, sometimes you got to hit rock bottom before you understand how important it is. So that's what we're going to do. I know that this seems harsh and that we're just giving you a hard time by putting you in jail, but actually we're trying to help you and get you back on track here. So I am going to remand the defendant with the idea that Ms. Jacobs is going to help get you into a treatment facility. You will be remanded to jail if you leave that treatment facility.
I don't have the money to go test, so that's the only reason why. Because the last time I went to jail is why I lost my job. Because when I went to jail last time, so I didn't have money to go testing.
Well, they'll do the testing. If you get admitted to a treatment facility, they have their own testing they do, and it's not going to cost you anything. And we'll figure out how to get all this to work. after you get out, okay? But that's what we're going to do for now. So you are remanded to jail, and Ms. Jacobs, you're going to work on getting that treatment bed and talk to NMRE about that, getting the funding, correct?
Yeah, so what we can do if she is remanded, I can come over and talk to her either this afternoon or within the next couple of days. If we can get this set up, then I can always, Your Honor, send you an action in court to release her to treatment, and then she would be let out of jail at that point to go to.
And you're going to make sure there's a secure transport to the facility. Okay. All right, then that sounds like a good plan. Anything else for you, Mr. Connolly?
No, Your Honor.
Okay, I hope you understand everybody's trying to help you right now.
I understand that. There is with some of the stuff that's been going on, I would I say about the other stuff that I'm not guilty of. And
okay.
So I just want
let's leave it at that. And so we'll deal with that if it becomes an issue for you. Okay, right now there's no charge.
Like pushing my name back to my brother. I mean, like we're all in the court system right now, and I feel like she keeps on targeting us and everything else. It's just not.
Okay, it might feel that way, but you know, facts are facts. And what I just heard about the drug report, you not testing, and Sergeant Knight, well, it all adds up. So anyhow, you'll need to have a seat over here, and good luck to you in the treatment facility.
Please stop looking.
Okay, what else have we got, Ms. Truesdell?
No, that's a different one. Your Honor, the final case is 22-3817. People versus Jarek Wamba, scheduled for a preliminary hearing this morning. This was also Ms. Farrar's case, but in speaking to Ms. Farrar and Ms. Hohan, we have an unavailable witness, and so even if Ms. Farrar were healthy, she would not be able to proceed because our witness, which is law enforcement, is unavailable. So this is our first request for an adjournment. This is a rather old case. I believe Mr. Wamba had.
Well, let's get Mr. Wamba on. He's in jail.